Good morning, good afternoon, or good evening, depending on wherever in the world you may be. On behalf of the Department of Law, North Southern University, it is my utmost pleasure to welcome you to this webinar. Our guest today is Professor Marko Milanovic. He is a professor at University of Reading. But before I formally invite our guest to deliver his talk, it is my pleasure to invite my esteemed colleague, our department chair, Barrister Arafat Hosen Khan, to give his welcome remarks. Arafat, over to you.
Thank you, Rizwan sir. Am I audible? Can you hear me, or can you see me? Okay,
please.
Great.
Yeah.
Thank you. Ladies and gentlemen, our esteemed faculty members, distinguished guests, and my dear students. Good evening from Dhaka, Bangladesh, and good morning, afternoon, evening from around the world, whoever is joining. We welcome to the NSU Law webinar, which is a regular NSU Law event to learn and connect with the global legal leaders. Tonight, it is both an honor and a pleasure to extend a warm welcome to you all as we embark on a journey of exploration and enlightenment with our distinguished guest, speaker, Professor Marko Marko Milanovic. NSU Law delighted to host this special event where we will look into the very interesting international law. Our esteemed guest, Professor Marko, is a renowned scholar in the field of public international law and served as a director of global law at the University of Reading School of Law. The themes of tonight's webinar, which is extremely important at this current situation or current moment in the world, which is coercion as an element prohibited in the international law. Professor Marko's expertise and insight promises to unveil the complexities surrounding this subject matter in the global framework of law, offering us a profound understanding of its implications and applications. As we gather here virtually, let us go through the journey of intellectual curiosity and open a dialogue. Let us engage in a thought-provoking discussion that will enlighten us on this very important topic. I extend my deepest gratitude to Professor Marko for generously sharing his knowledge with us and also his time with us, and to all of you for being a part of this enlightening journey. Without further ado, let us begin this evening's webinar with an open mind and to get the knowledge as much as we can gather from this discussion. Thank you and enjoy the webinar.
Thank you, Arafat, for your welcome remarks. Before I invite Professor Milanovic to deliver his talk, the listeners, I should have reminded you, or I should have told you maybe at the beginning, that this talk is actually based on his very recently published article in, I could say perhaps safely, although I know Marko is very closely connected to ISIL, so maybe at the risk of sort of be in a way differing with Marko, I would say that ISIL is in international law circle perhaps, along with ISIL, with which Marko is very closely connected, is the leading law journal in the field of international law. So I would echo Arafat's sentiment that it is our privilege to hear from him. Marko, over to you. Thank you.
Thank you so much, Rizwan, and thank you, Arafat, and thank you for having me. It's a great pleasure to be with you. So yes, as Rizwan was saying, the talk that I will give is based on a recent article of mine, which the notion of coercion as an element of prohibited intervention in international law. And it was published very recently in the American Journal of International Law. So if you just Google my name, coercion, it'll pop up and you can find it. It's open access. And it's a very long article. So what I'm not gonna here go through like every single point in that article. What I intend to do in this talk is to give you the core of the argument and to explain why I think it's important or relevant. So let's start with just a teeny tiny bit of background. The rule that I'm exploring in that piece and here in the talk is the prohibition of intervention, also known as the principle of non-intervention. And that rule is very easy to say, okay, to state at a very basic level. It goes something like this. No state may intervene in the internal or external affairs state. Now that's the rule. So international law prohibits one state from intervening in the internal or external affairs of other states. That's the core of the rule. Now the question is what this rule means and how it applies in contemporary international relations. The core problem, in a sense, is that it seems to say, the rule seems to say, that some kinds of interactions between states are prohibited, but in fact, states relate to each other all the time on all sorts of issues. And then the question is, at what point in time does that type of interaction become illegal? At least illegal as intervention. Now, to sort of go back a step, that rule is part of customary international law. It is not set out in any treaty at the universal level, so you will not find it in the UN Charter. There is a separate prohibition in the UN Charter, Article 2, Paragraph 7, that prohibits the organization, the UN, from intervening in the internal affairs of its members. But that's a separate rule from the one I'm discussing here, which is about states. Yeah. The rule, as I said, is part of customary international law. It is today universally regarded as such. Its moment of crystallization or codification came in a series of UN General Assembly resolutions in the second half, obviously, of the 20th century, culminating in the Friendly Relations Declaration, which sort of sets out the most authoritative statement of the rule. The case of the International Court of Justice, which is sort of the classical point for examining this rule, is the Nicaragua case. So this is Nicaragua versus the United States in 1986. And you'll remember back in the day, at the height of the Cold War, the United States was intervening in multiple ways in Nicaragua. And one thing it was doing, it was supporting the rebel groups called the group called the Contras. It was providing the Contras with weapons, with training on how to use these weapons, with intelligence information, with money. And all of this was being done with the basically stated purpose of overthrowing the left-wing Sandinista government of Nicaragua. Now, Nicaragua sued the United States. The court in the case found that some aspects of what the United States did violated the prohibition of the use of force in Article 2, Paragraph 4 of the Charter and its customary equivalent. Specifically, the court said when you provide weapons to rebels in another state, that's a use of force, an indirect use of force. But the other forms of support, funding the rebels, giving them intelligence, the court said this is not a use of force. This is, however, illegal intervention. Yeah. So I'm just sort of, setting the stage basically for what the court did in that case. Now, importantly, the court also gave some kind of definitional remarks on what it means by the prohibition of intervention, or how it interprets the prohibition of intervention. And so this is a very famous paragraph in the case where the court says that the principle of non-intervention forbids all states or groups of states from intervening directly or indirectly in the internal or external affairs of other states. A prohibited intervention must accordingly be one bearing on matters in which each state is permitted by the principle of state sovereignty to decide freely. One of these is the choice of a political, economic, social, and cultural system, and the formulation of foreign policy. This is the first element of the prohibition of intervention, what we call internal or external affairs, sometimes also called the reserved domain or the domaine réservé. So all matters on which a state is permitted to decide freely. Yeah. Then the court moves to the element I'm interested in most of all. And it says this: intervention is wrongful when it uses methods of coercion in regard to such choices, which must remain free ones. The element of coercion, which defines and indeed forms the very essence of prohibited intervention, is particularly obvious in the case of an intervention which uses force, either in the form of direct military action or in direct form of support for subversive or terrorist activities within another state. So the court basically said, not every interference with the internal or external affairs of another state is unlawful. Not every interference is intervention. It is only intervention if it uses methods of coercion. Yeah? Then it becomes unlawful. So let me give you an example. Here in my country, Serbia, and I know something similar happened recently in your country, we had elections. Yeah. Now, it just so happened that the election results have been controversial in the sense that the political opposition accuses the government has been in power here for 13 years or so, of essentially stealing parts of the election, of manipulating the election results. So if another state, Germany, comes to Serbia and tells Serbia, you know what, we don't think you organized your elections in a manner that fully comports with international standards. We don't think your elections reflect the real will of the electorate. In particular, you control the media, you suppress political criticism and dissent, and we don't like that. So if the German ambassador to Serbia said that tomorrow to our president, that would be an interference in the internal affairs of Serbia, our elections. Yeah. So as the court said, some choices are choices for each state, matters on which it's supposed to decide freely. One of these is the political system. This interference, however, is not unlawful. Yeah, it's just talking. A German diplomat talked to the Serbian president about something in our internal affairs. There is no coercion. You see what I mean? So as far as the ICJ is concerned, an interference would become unlawful intervention only if Germany employed methods of coercion vis-a-vis Serbia, for example, to compel the Serbian government to open up a TV channel for opposition political parties. Yeah. Depending on how Germany did that. So the key issue, for example, is this. if Germany threatened Serbia with economic sanctions, unless Serbia complied with its demands, would that be coercion? Would that be intervention? Yeah. I hope I'm making sense, right? So the court basically said, for an interference with the internal or external affairs of another state to be unlawful, it has to be coercive. Now, the court said, remember, coercion is the very essence of intervention. But very interestingly, it does not define at all in the remainder of the case what it means by coercion. It treats the concept as if it was obvious. So it does say later on, when it applies this rule to the facts, it does say, as I explained, that supporting rebel groups on another state's territory crosses this threshold of coercion. But then Nicaragua also complained that the United States imposed all sorts of economic sanctions on the country. And the court very laconically, in just one sentence, says, well, these economic sanctions, they're not coercive, they're not intervention. Yeah. Now, from that case onwards, we've had decades of debates, in scholarship, in the UN, about what this term coercion means. In fact, there's a whole strand of General Assembly resolutions condemning resort to so-called unilateral coercive measures, specifically economic sanctions, generally being used by Western countries against other countries. Yeah. These resolutions have generally attracted a lot of opposition. The Western countries that use them are certainly not going to vote for resolutions condemning their own practice. So in the global South in particular, economic sanctions have always been treated as something controversial, maybe even unlawful, something that is being used by powerful countries against them. But for my purposes, really the question is, what does this concept of coercion mean in the non-intervention setting? Now, the reason why I got interested in this topic is because I started working in this whole area of how international law applies in cyberspace. And I'm now one of the co-editors of this ongoing project, Talent Manual 3.0, on the application of international law to cyberspace. And the core idea of this project is that we have all sorts of old rules of international law, including the prohibition of the use of force, the principle of sovereignty, or the prohibition of intervention, and that these rules can be applied to new phenomena such as cyber. And in the cyber context, you have this kind of interesting question, when do certain cyber operations violate the prohibition of intervention? For example, if I have elections in my country, in Serbia, and the state of Bangladesh runs cyber operations here in order to influence the election, is Bangladesh intervening in the internal affairs of Serbia coercively? That's the question. And the issue depends probably on the type of cyber operation. For example, if Bangladesh hacked our Central Election Commission, hacked its servers, and changed the results of the election, most scholars until now have been very content to say, well, that is coercion. That violates the prohibition of intervention. But what about other types of cyber operations? For example, if Bangladesh was spreading mis or disinformation on social media in order to influence parts of our electorate or to suppress the vote or something like that, is that type of election interference of the kind that, for example, Russia did in a past US election at least, does that cross the threshold of coercion? So that's how I got interested in this question. I really wanted to understand how we should apply this idea of coercion in the cyber setting. But when I started thinking about this, I realized you cannot really have a cyber-specific answer. You need to have some kind of general answer. about what coercion means. And in arriving at that answer, or at least at the proposal of such an answer, I relied heavily on many, many recent statements, dozens of them now, which are formal expressions of opinio juris made by states specifically in the cyber context, where they talk about the principle of non-intervention. And I also relied on some non-cyber recent developments, such as the EU anti-coercion instrument, which I'll talk about in a minute. So that's sort of the setting of the scene, if you will. You know, that's how we get to the core question. You know, what do we mean by coercion? And here is sort of my answer. My argument, the argument I put forward in the article, is that there's really two different ways of thinking about coercion, both in this particular context of non-intervention, but probably also more generally. And that a lot of confusion or controversy about the principle of non-intervention stems from the fact that until now, we have not been able to really clearly distinguish between these two different ways of thinking about coercion. Now, what are they? I call them coercion as extortion and coercion as control, or the extortion model of coercion versus the control model of coercion. Now, what do I mean by that? The extortion model of coercion, or coercion as extortion, is the situation in which a state makes a demand of another state, threatens that state with harm if that demand is not met, and then implements that harm if the target state does not comply with the demand and the threat. Yeah. So coercion as extortion has this demand, threat, harm structure to it. Yeah. Its core idea is that the infliction or threatened infliction of harm influences the decision-making calculus of the leaders of the victim state. Basically, they're told, do what we say or else, or there will be pain. You know. So let me give you some examples. In 2017, Saudi Arabia and a coalition of Gulf states allied to Saudi Arabia issued an ultimatum to Qatar. And they told Qatar, you need to comply with a list of, I don't know, a dozen demands. The demands include cutting off ties with Iran and Turkey, shutting down the Al Jazeera TV station, stopping your meddling in our own internal affairs, etc., etc., etc. So that's the demand. And then the Saudis told the Qataris, if you don't do what we say, we will impose harm on you, which they did. So they cut off trade, economic relations. They kicked out all Qatari nationals out of their countries. They stopped Qatar Airlines from flying over their airspace, etc., etc., etc. And that so-called blockade of Qatar, which at one point even included the threat to physically dig a canal between the Arabian Peninsula and the peninsula of Qatar, yeah, persisted for years. And Qatar, like quite a few states in this kind of situation, managed to successfully resist these demands, never comply. Recently, you know, Qatar and the Saudis sort of made up, and now they're friends again-ish. Yeah. So that's one example. Another example, last year, Russia tells Ukraine, basically, do what we say, remove your government, replace it with the government we like, demilitarize, or we will invade you. Yeah? Ukraine doesn't do that. Russia uses, in February 2022, you know, its mass of military force and invades Ukraine. Yeah? So there's a demand, there's a threat, there's a harm. The United States and Cuba. Yeah, so the United States has kept Cuba under embargo for 50 years now, all with the stated purpose of changing the government, the regime in Cuba. The embargo has been hugely harmful to Cuba. You know, it's a country that lives really in the past century, but Cuba has nonetheless managed to resist that embargo. So this is the coercion as extortion model. Remember, there's a demand, there's a threat, there's a harm. And the issue really is, at what point, when you have this kind of dynamic, at what point of threatened harm can we say we have coercion that is unlawful, right? Where do we have that threshold? Here we have some easy cases of what coercion is and some easy cases of what coercion is not. And everything else is in some sense a hard case. So the easy case of what coercion as extortion is if you threaten to use force, unlawful force, yeah? That's easy. So that's the same thing as if I, in domestic law, approached Rizwan on the street, pointed a gun to his face, and I said, give me money or else, yeah? So that's coercion as extortion. If you threaten violence, if you threaten force, you have coercion. The same goes for the example we have, certainly in the Nicaragua case, of supporting rebels in another state. Yeah, so that's also an easy case of coercion. If I threaten that I will support rebels in your country if you don't do what I say, that is coercion. It's also easy to know what coercion is not. If the only thing you do is talk to the other state and try to persuade them rationally to take a certain course of action, that is clearly not coercion. That is just vanilla diplomacy. So, for example, the United States has been sending its diplomats for I don't know how many years now, all over the world, telling every country, please don't buy Chinese technology in your 4G, 5G telecommunications infrastructure. It's unsafe. Don't buy it. Yeah, use better things. Use the technology of some other country. That when the US ambassador comes to Dhaka or comes to Belgrade and says, don't buy Chinese technology, that is clearly an interference with our internal affairs. It's also clearly not coercive. All they're doing is talking to us. Now, what is a hard case? The hard case is when the US ambassador tells us, well, if you don't do what we say, there will be some consequences. You know that trade arrangement we have, well, we might suspend that. You know that investment arrangement we had, well, we might suspend that. You know that intelligence cooperation agreement that we have, well, that's not going to work anymore. You know how you wanted to buy our weapons, well, that's not going to happen anymore. You see what I mean? So the question here is the difficult one. When the threatened infliction of harm is not force, but something below force, at what point do we have coercion? I'll come back to this. So this is the first model of coercion, coercion as extortion. The second model of coercion, however, which I think works very differently from the first, and really must not be conflated with it, is coercion as control, as deprivation of ability, the ability of the victim state to control its internal or external affairs. So here, the best example, the starting example, is actually the Nicaragua case. In the Nicaragua case, the court basically said, as soon as you start supporting rebels in another country, there is coercion, there is intervention. You don't have to make demands and threats. The mere fact of supporting rebels in another state deprives essentially that state of the ability to fully exercise its sovereignty on its territory. At that moment, there's already coercion. Yeah? So if, for example, unbeknownst to Bangladesh, Serbia was now supporting a rebel group in Bangladesh, that would, in my view, be coercion. You might not even be aware of it. You might have no idea that the Serbian government is spending billions of dollars to support a rebel group. But it is still unlawful. You see what I mean? The mere fact of supporting a rebel group without any kind of demand or threat is sufficient to count as coercion. And here we come to cyber. Here is where cyber operations fit in. Imagine, for example, tomorrow, or well, let's go back to 2021 or 2020. Imagine Serbia hacked Singapore and prevented Singapore from managing its pandemic response, from conducting COVID testing, from distributing COVID medications or vaccines or whatever. Through that hack alone, Serbia would have deprived Singapore of the ability to control its internal affairs, how it responds to an epidemic. Yeah? Or if tomorrow Serbia hacked elections in Bangladesh, and Bangladesh was not aware of this, yeah, the mere fact that we hacked your elections would be enough to constitute intervention, coercion in your internal affairs. Yeah, we deprived you of your ability to control your political system. So, if you want to have a domestic law analogy, we have these two different types of coercion in domestic law, in domestic settings too. For example, domestic criminal law, all of it, is coercive in the extortion sense. There's a demand. Don't commit a crime. There's a threat. If you commit a crime, we're going to punish you. Yeah? Then there is the punishment. The police are going to investigate. They will arrest you. They will put you in trial. You will be punished. Yeah? So all of domestic criminal law is coercive in the first sense. But there are other types of coercion in domestic law as well. Coercion as deprivation of control. If, for example, the Serbian police just walk into my house here now and arrest me, and they put me in jail, that is an exercise of coercion over me. If the Serbian government tomorrow seized money on my bank account, that is an exercise of coercion over me. If they took my house, that is an exercise of coercion over me. Even if there is no demand, there is no threat. You see what I mean? I am being deprived of the ability to control some of my rights and interests. So the same logic, I submit, applies in international law as well. We need to clearly distinguish between these two different forms of coercion, which work in different ways. The first form of coercion works by affecting the decision-making calculus. If you don't do what I say, bad things will happen. The leaders of the victim state know this is happening. They have to evaluate the costs, the harms inflicted on them, and they have to make their choices. In the second type of coercion, though, the victim might be completely unaware of what is happening to them and who is doing it. Yeah? So another state might be supporting rebels on your territory, or hacking your financial system without you having any sense of who is doing it, without you even being aware that this is being done. Yeah. So that is really my core argument, that we have these two different types of coercion that need to be clearly distinguished. Now, I am making it up, this distinction, but I think that distinction is supported by recent state practice and opinion jurists. And I will just here very briefly talk about two such examples that I would suggest you look at if you're interested in this topic. The first example, which pertains to coercion as extortion, is this new instrument, new piece of EU legislation, which just entered into force, just a few weeks ago, which is called the European Union Anti-Coercion Instrument. Now, what is this? This is a legal framework of the EU, which essentially says this: if other countries attempt to coerce the European Union or its member states by economic means, by essentially inflicting economic harm on us, that is unlawful. That is an intervention in our internal or external affairs. And we will respond through various measures, which may include countermeasures in the sense of international law. So violations of international law done for the purpose of compelling the original violator of complying with its duties. Yeah. So the EU, if you look at the piece of legislation, very, very, very clearly situates this entire framework in the context of the international law prohibition of intervention. And it is interesting to see how it defines the notion of coercion. So, for example, the EU's the anti-coercion instrument says that coercion is prohibited and therefore a wrongful act under international law when a country deploys measures such as trade or investment restrictions in order to obtain from another country an action or inaction which that country is not obliged to perform under international law, which falls within its sovereignty, when the coercion reaches a certain qualitative or quantitative threshold, depending both on the objectives pursued and the means used. So this is clearly a coercion as extortion. The EU is concerned, if you look at the history of this, at coercive measures of economic nature used against EU or the EU countries by the United States and China, really the two powers in the world that are even capable of coercing the EU. And this is what this anti-coercion instrument is really meant to respond to. So the EU is saying you're not allowed to use these types of measures in order to obtain something from us that we're not obliged to give you under international law. Yeah. Now, interestingly, there's this now whole initiative on economic coercion taken in the context of the G7. So at their recent summit in 2023, the G7 decided to form a new task force on economic coercion. So the EU is not alone in this regard. Now, I hope you saw how the EU instrument refers to a certain quantitative or qualitative threshold. Basically, the message the EU is sending is that coercion does not necessarily need to violate the rights of the EU or its members. What's important is that the measures are severe enough. When the harm is severe enough, the EU can treat it as unlawful intervention, as coercion, and respond accordingly. So that's the first model of coercion as extortion. If you want to look at evidence of recent practice on coercion as control, I think it is very good to read the recent position papers of the UK, Australia, New Zealand, and Canada when they try to apply the notion of intervention to cyber operations. And if you look at the definitions they give, I think they quite clearly reflect a coercion as control model. So for example, Australia says, Coercive means are those that effectively deprive the state of the ability to control, decide upon, or govern matters of an inherently sovereign nature. New Zealand says there's coercion if there is an intention to deprive the target state of control over matters that fall within its sovereign functions. Canada says coercion includes activities that would cause coercive effects that deprive, compel, or impose an outcome on a state on matters in which it has free choice. So all of these statements, I think, point quite heavily towards a coercion as control model. Now, just to be clear, the two models of coercion are, in my view, completely complementary. They exist side by side. Yeah? You can violate the prohibition of intervention either by coercion as extortion, by making demands, threats, and imposing harms on another state that cross a certain threshold, or through coercion as control, by depriving the victim of its ability to control its internal or external affairs directly without making demands or threats. So that is sort of the core argument that I make in the piece, and I hope that made some sense, and I'm very much looking forward to your questions.
Thank you, Marko, for your excellent talk. We have a few questions. Now, the first question that I would like to ask you is on that, as I think you have mentioned in your article, that our writer is saying that at one level or another, maybe even in our personal relationships, we often coerce each other. Now, it's very difficult, but in practice, the kind of persuasive scenarios that you have mentioned is clearly you are arguing that they are not coercive. Can, in some situations, those so-called quote-unquote persuasion meet the threshold of coercion? Can it change over time? Can you give any example? Do you have any views on that? Thank you.
So, I mean, let me give you an example. I think persuasion alone is not coercive. It's when persuasion becomes coupled with something else that it becomes potentially coercive. And this can be something like exploiting a relationship of dependency. Yeah. So, I mean, let me give you an example. Sri Lanka takes billions of dollars of loans from all kinds of countries in the world, including from China. And then when China tells Sri Lanka, you know what, we want you to do something. We want you to give us a port. Yeah. And if you don't do that, we're going to wreck your whole economy, which is already sort of wrecked. Yeah. That kind of threat can, in my view, be coercive. Yeah. It doesn't, so the threatened harm does not have to violate the law if it's severe enough. So if the threatened harm violates some other rule of international law, you know, the situation is fairly straightforward, I would say. There may be several examples, and I explore them in the piece, of states threatening or doing unlawful things to coerce another state to do something. A very interesting example here is so-called hostage diplomacy. So this was practiced by both Iran and by China. You know, you take, I don't know, a bunch of Canadian citizens, British citizens, whatever, put them in jail and say, if you don't do what we say, you know, these guys are going to stay in prison. So that kind of coercion is easy, I would think, because it already violates some other rule of international law, like human rights. But the argument I make in the piece is that even lawful measures can become coercive if the harm is severe. So in the example I gave, like if the economic impact of your threat is so grave that millions of your people will starve, you have no real choice. Yeah, you are really being coerced. Even if, you know, there is no duty by China to give you money, yeah, or you are obliged to pay them back. You see what I mean?
Thank you so much. Now, you mentioned that Nicaragua point that generally speaking, economic sanctions would not amount to use of force or maybe coercive. Do you think that the court in that particular case was persuasive enough, or I would say, was it in somehow dealing with that issue in a very perfunctory way that it did not give enough justification for it? Would that be a fair criticism of Nicaragua judgment, you think, or you view it in a different way? Thank you.
No. I completely agree with that, right? So maybe you can defend the outcome of that judgment. I don't think you can defend the reasoning or lack thereof, right? So the court never explains why the economic sanctions imposed by the US on Nicaragua were not coercive. Now, maybe there's a good reason, but they don't explain it. The reason behind it is that historically, a whole bunch of states, Western states in particular, used economic sanctions. And for the court, therefore, you cannot really say that economic sanctions as such are unlawful. And I agree with that. Yeah. I am saying, however, that if you make a demand of a country to do something that it is not internationally obliged to do, and then you couple that demand with a threat or infliction of economic sanctions that are severe enough, then economic sanctions become unlawful. Yeah. So if you use economic sanctions to get a country to do something it has every right to do, like to give you an example again, if Russia didn't invade Ukraine, but if Russia imposed crippling economic sanctions against Ukraine because Ukraine decided to join the EU or NATO, that, to my mind, is still coercion. You don't have to invade them to coerce them.
Thank you so much. Next question is from Amir Hamza. His question is, regarding the proposed severity approach to coercion as control, how do you suggest addressing situations where the severity of impact may be subjective or difficult to quantify? Can it lead to some sort of ambiguities?
The answer is definitely yes. Yeah. So just to clarify, so the severity threshold, I think, can apply with some distinctions, both to coercion as extortion and coercion as control, right? So the same kind of considerations will apply for both models. I think there's certainly some truth to be said that different countries have different capabilities and different resistances. And so if you threaten Serbia with, I don't know, $1 billion of economic harm, that is really, really harmful to us in a way that it would not harm Norway or would not harm the United States. It's peanuts to them. You see what I mean? So the impact has to be measured in some sense by the circumstances of the victim, of the target state. And you need to look at their capabilities, at least partly, in assessing the severity of the impact. And sometimes that kind of assessment will lead to an uncertainty. Yeah. But I think there will be clear cases. And just to be clear, there is one point that I think is completely clear. The fact that coercion doesn't work in producing its intended result doesn't mean there was no coercion. Yeah? There is no requirement that coercion has to be successful. So again, look at Cuba. Cuba has suffered, I can't even quantify how many billions of dollars of economic harm and social harm of all sorts of kinds imposed by the United States. Yet still, Cuba has managed to resist American demands. Huh? But to my mind, I think Cuba has certainly been coerced. Yeah. The fact that they successfully defended themselves or resisted in some sense does not change the fact that they've been coerced. In the same way that, for example, if Serbia now tried to hack elections in Bangladesh and your cybersecurity agency discovered the intrusion and protected your systems, we would still say, well, there was coercion. It failed, but there was coercion. Or if I know Serbia bribed some generals in Bangladesh to organize a coup against the government, but the government uncovered the plot and arrested the generals, so there was never a coup, there was still coercion. Yeah? So coercion doesn't have to succeed, if you see what I mean. It doesn't have to be completed to be unlawful. And don't take my word for it. Take the word of the General Counsel of the U.S. Department of Defense, who in a recent speech made exactly that point, that for coercion to be successful, to require coercion to be successful would lead to paradoxical results and would disadvantage those states that are actually be able to defend themselves. So I hope that answers your question.
Thank you so much. The next question is from Fateha Noor. Her question is, what ethical considerations arise when differentiating between coercion as extortion and coercion as control? Are there scenarios, where one model may be considered more ethically justifiable than the other?
So this is a really good question. I don't think the justification issue, the ethical issue, as you put it, necessarily turns on this distinction between extortion and control. But I do think this justification issue permeates the whole debate about the principle of non-intervention. So there is actually a section in my article that talks about what I term the problem of justification. So if you read the sources of the non-intervention rule, they say something like, the Friendly Relations Declaration says something like, no intervention for any reason whatever in the internal or external affairs of another state. It seems like the rule is absolute, that there's no way to justify coercion anytime. But actually, I think there are plenty of situations where using coercive measures is justified. Yeah. So let me give you an example. Russia invades Ukraine, and what do Western countries do? For example, they impose sanctions on Russia. What do? They seize Russian assets. Yeah. Now, these actions are, to my mind, coercive, but they're justified. Now, how does that fit into the non-intervention rule? I think this whole process of justification really works through the reserved domain element of prohibited intervention. Remember, it's only intervention if you have both coercion and an interference with the state's internal or external affairs, matters on which each state is permitted, the court says, to decide freely. So if you use coercion against another country to make it comply with international law, obligations that apply to that state, then you are not, through that coercion, violating the prohibition of intervention. So that's the argument I make in the piece. Yeah? If you use economic sanctions, you use any other measure solely for the purpose of enforcing compliance with international law, maybe that violates some other rule of international law, but it does not violate the prohibition of intervention. Good. I hope that answers your question.
Thank you, Marko. Thank you so much. I know you have another commitment, so this would be my last question to you. When it comes to the state practice, obviously, we all know that it may be so easy, as you have cited the examples of China, the US, for them to coerce other states is not really maybe an issue. So I was wondering that, is there any variance in state practice when it comes to the views on coercion? That do third world countries take any particular kind of views on these, or there is generally a broad agreement about many of the core issues. Any views on that? Thank you, Mark.
I think, thank you so much, Rizwan. So I think third world, global south countries, whatever, have taken this stance against unilateral coercive measures as such that the mere fact that there's a measure that is unilateral somehow makes it unlawful. And that, to my mind, is a far too sweeping position. Yeah? That would mean literally that if Russia invades Ukraine, the UK still has to trade with Russia. Yeah? And is not permitted to cut off trade to Russia or to do anything else to Russia, even though Russia just committed aggression. It would mean Bangladesh could do nothing to Israel, even though Israel is violating the human rights of Palestinians or whatever. You see what I mean? So taking a completely categorical stance against unilateral coercive measures in a system where multilateral institutions rarely work, where the Security Council is blocked all the time, is not, in my view, a sensible approach. And it has been resisted by so many other states. Yeah. On the positive note, though, if you look at the developments now in the G7 and the EU anti-coercion instrument, suddenly all of those Western states that historically said, no, economic sanctions are perfectly fine, they're just a tool of statecraft, suddenly all of them are saying, wait, there will be situations where using them is unlawful, where using them is coercive and therefore violates the prohibition of intervention. And I think that's a good thing. Actually, I think we are now witnessing some kind of convergence of positions between the West and the rest. Actually, there will be some situations where all of these states will agree that coercion is unlawful.
Thank you so much. I hope that maybe in someday in our lifetime we will see that convergence. I don't know when and how, but maybe there is a reason to be optimistic. Thank you so much, Marko, for your excellent talk and for all the answers and for your time. Have a good day. And thanks to all the audience for their time.
Bye now.